for this opportunity. Today we have former Ambassador Walid Abdelnasser. He is the director of the Bureau of Arab Countries in the World Intellectual Property Organization. He will discuss the connection between intellectual property and development in North African countries. To say that intellectual property is important is an understatement. Technology has always been behind the development. At the very beginning, development is not that old. It started in the Industrial Revolution. And it was a result of technological improvements that we experienced the first Industrial Revolution. Then we have experienced the second, the third, according to scholars, even the fourth Industrial Revolutions. But they all have in common technological improvements. Intellectual property is closely connected to technology. And there are different approaches to intellectual property. For those states that base their development on innovation, intellectual property can provide protection. But the world is quite diverse, and IP may need different approaches according to the development stage of different countries. So a good design of intellectual property regimes is key to deliver the development that is so much needed in some areas of the world. So this is the topic that we're going to cover today. And for that, Ambassador Walid, the floor is yours.
Thank you very much, Professor Miguel. Thank you for this kind introduction, this also substantively important introduction. I would like also to thank the Institute here for inviting me, for being here with you this evening, and thank friends who I have met with earlier today at the University of Barcelona, the faculty of law, that I can see them here as well. It's a great pleasure to meet them again, and a great pleasure for me to meet those I'm seeing for the first time in this session. It's a great pleasure and honor to be at the Institute and to be in Barcelona and to be at the university also this morning, where I talked about another subject. But now I'll be talking about the IP in North Africa and the North African countries. Just to share with you the outline, and talking about the historical developments of the IP systems in the countries of North Africa. And then I'll be talking about opportunities and challenges for North African countries in the current IP regime. The importance of the regime has been highlighted by Professor Miguel just now. The third point will be the role of the WIPO, the World Intellectual Property Organization, in fostering the use of IP as an engine for growth and development in North African countries. And I'll just take a sort of a brief overview of what activities actually the World Intellectual Property Organization, through the Regional Bureau for Arab Countries, which I have the honor and pleasure of being its director, are currently undertaking and have been undertaking for the past 5 years in the North African countries. Finally, I'll share with you some conclusions. Before going in that, I just want to highlight the fact that the World Intellectual Property Organization supervises and administers the implementation of 26 international treaties and conventions in the area of intellectual property. So these 26 treaties, they vary between what deals with patents, what deals with trademarks, what deals with geographic indications, industrial designs, copyright. And there are several ongoing, let's say, negotiating process in the World Intellectual Property Organization over the past years that haven't concluded yet successfully to reach the stage of reaching what we call diplomatic conference. Diplomatic conference is usually called upon to be held once there is preliminary and general agreement among the member states and the different groups in order to be able to reach agreement. So once there is such a guarantee, then the diplomatic conference is called upon to be convened. So one example for this is what we call is the IGC, the Intergovernmental Committee on Traditional Knowledge, Genetic Resources, and Traditional Cultural Expressions. These negotiations have been going on since 2001, so since 19 years and still going on. Another one is the draft, the draft design law treaty, and the third one is a revised agreement or revised treaty on broadcasting, because there already exists one on broadcasting, but it's quite really old and it has been bypassed by many technological developments. And as Professor Miguel mentioned correctly in his presentation, that technology is an important factor in determining intellectual property rights and even in determining the definition of intellectual property, which we have to revise with the advancement of different technologies. Having said so, I'll just move to the sort of definition of, there is no definition for intellectual property, but what intellectual property covers, which I shared just with you now. It covers patents, and patents is, until now, is the most important component of intellectual property. I mean, with all the due respect to the growing importance of trademarks, for example, or industrial designs or copyright, but patents is the bulk of what we call intellectual property. After that comes trademarks. Trademarks is the second in that line of importance. Patents are, or the international regime of patents is governed by several treaties, but the most important current one is the PCT, the Patent Cooperation Treaty. The trademarks, again, there are a number of treaties and conventions dealing with trademarks at the international level, but today the most important is what we call Madrid Protocol. There was before something called Madrid Treaty, but this have been superseded by the Madrid Protocol. The international design area, we had the Hague Convention on International Design for many years, but then now again there is what's called the Geneva Act of the Hague Convention. So this is sort of a revised, more advanced version of it that is currently going on. Copyright, of course, copyright is different because copyright has been traditionally, since 1883, since the Berne Convention has been there. The important development in copyright were twofold. One, what we call the two Internet treaties in 1995-96, and the Broadcasting Treaty, which is currently under revision. So this is the main items. There is one controversial, let's say, controversial component, quote unquote controversial in terms of its the terminology used of IP. The European countries and many other countries who follow the European system in IP, they call it geographical indications. According to the American system and other countries that followed the American system, particularly in Latin America, they consider it part and parcel of trademarks. They consider it, let's say, specific type of trademarks, but they don't recognize it as something separate, as the case with European countries, which and some other countries in the world that follow the European model that call it geographic indication. But in any case, we have a treaty in one of the treaties administered by the WIPO called the Lisbon Treaty. And then we have in 2015 the latest agreement called the Geneva Act of the Lisbon Treaty. So these two are on geographic indications. This is the overall situation. Having said so, I should say also that there is a humanitarian dimension or a human dimension of IP treaties, international IP treaties. How you'd ask me how this would come from? We have the Marrakesh Agreement. The Marrakesh Agreement of 2012. This is made exceptions for intellectual property rights for the blind and visually impaired. So this Marrakesh Agreement, and now there are more than 80 countries worldwide that joined the Marrakesh Agreement, is one of the fast growing in the world in terms of joining it by member states. So it's growing very fast, and it's clearly putting, I wouldn't say a restriction, but an exception from intellectual property regime in favor of the blind and the visually impaired. It's basically, of course, on the copyright aspect of it. So this is just a general overview of intellectual property in general, its components. Now I move to talk to you about the historical development of the IP systems in the countries of North Africa. And when, of course, we talk about the countries of North Africa, we're talking about Mauritania, Morocco, Algeria, Tunisia, Libya, and Egypt. So these are the countries of North Africa, according to the definition we use, and all of them come under the Regional Bureau for Arab Countries in the WIPO. So we had the first, as I mentioned, we had two historical conventions that laid the foundations for the international IP regime: the Paris Convention for Industrial Property and what I already mentioned, the Berne Convention. The Paris Convention, which was adopted in 1883, it established the general principles concerning protection of industrial property. And here we had the principle of the national treatment, which came also in many international trade agreements. It started in IP as early as 1883 with the Paris Convention. The Paris Convention was followed by many Arab countries. Actually, nowadays, almost all Arab countries are parties to the Paris Convention, or all of them, not almost all of them are parties. But historically, we should say that the first Arab country that joined was Tunisia. Tunisia joined in 1884, so 1 year after the adoption of the Paris Convention. Morocco was the second country, and it was 33 years later, in 1917. In the 50s and 60s and 70s, we had the eras of independence of the countries of North Africa. And these 3 decades witnessed an increasing... okay, sorry. I'm sorry. My voice, I'm sorry, is a bit weak, but I'm suffering from a cold, so I'm sorry. Try to get it. In the post-independence era for these countries of North Africa, all of them became part of the international IP regime. At the same time, they became part of the international trading system. And this has a lot of correlation that I'll touch upon in just a few minutes. We have Libya, for example. Libya gained its independence in 1951. In 1959, it had already its patent and industrial design law. If we move to other countries, we'll have that Morocco was the first North African country that joined the WIPO. WIPO was established in 1970. Morocco joined in 1971. Algeria, Egypt, and Tunisia, 3 other countries, followed in 1975, and Libya was the last in North Africa to join in 1976. As I mentioned today earlier in my, former presentation, the fact that many developing countries didn't join WIPO from the beginning in 1970 was for the reason that they saw WIPO as a rich man club, as an organization for the industrial country, for the developed, wealthy Western countries that simply wants to protect intellectual property rights and want to impede the transfer of technology to the developing countries. And again, this brings us back to the centrality of the question of technology, as I'll go through some of the activities we do in the region in a few minutes. We had a very important evolution in the 1990s. We had the Uruguay round of multilateral trade negotiations, which was one of the longest rounds. It started in 1986 and was concluded in 1997. This round was very unique in the fact that it turned the international organization dealing with international trade from what was established in the aftermath of the US Congress rejection of establishing a World Trade Organization after Second World War. And then there was the establishment of the General Agreement on Tariff and Trade with very limited mandate in terms of international trade. This was replaced as a result of the Uruguay round by the World Trade Organization in 1997. Sorry. But if we go back to the GATT itself, the General Agreement for Trade and Tariff, we'd find that for the countries of North Africa, Egypt was the first country to join, 1970, followed by Morocco, 87, and Tunisia, 1990. Libya and Algeria, actually, they didn't join the GATT. Algeria has been applying for membership in the WTO, but still being negotiated. if we go one step further in order to elaborate more on the TRIPS, or the Trade-Related Intellectual Property Rights Agreement of the WTO, which came into effect on January 1st, 1995. This is perceived in the world today as the most comprehensive legal framework for IP. Why is it perceived in this way? It's simply because it's not the first international agreement in the IP, but it's the first legally binding, meaning that it has in its text sort of certain provisions for either sanctioning countries that do not follow its provisions after joining the agreement, or even a sort of compulsory compulsory dispute resolution mechanism and procedure that could reach decisions or judgments that would be detrimental to the interests of the country that violated its commitments under this agreement. There were three main novelties of this TRIPS agreement. The first was the standards. TRIPS sets out minimum standards for the protection of intellectual property to be provided by each member. So each member that wanted to join the WTO had to go through sort of negotiations with the WTO Secretariat, and through the Secretariat, the member states. In these negotiations, the country would say what it's willing to make as concessions, because at the end of the day, we are talking about sovereign states. And in this negotiating process, the country let's say, put its maximum. Then the Secretariat goes back to the member states. Member states, or some of them, are not convinced of this maximum. They want more. So the Secretariat goes back to the country and asks for more, and goes in a negotiating process until the country accepts TRIPS. The minimum is the commitments under TRIPS. There hasn't been any exception provided for any country in this respect. The second novelty in TRIPS was the enforcement, which I just referred to earlier. There are a set of provisions deals with domestic procedures and remedies for the enforcement of intellectual property rights, as well as the international implications of differences or disputes related to this process. The third novelty was dispute settlement. The agreement made disputes among WTO member states about the respect of their commitments under TRIPS, subject to WTO dispute settlement procedures and what's called the appellate body, which is more of a legal body within the organization that had, for many years, had actually taken decisions and passed judgments that were clearly in favor of countries against other countries in terms of petitions or complaints related to IP. Nowadays, I'm sure maybe some of you or all of you know, this appellate body has been frozen in the past couple of years or so due to disagreement between major parties in the WTO about its operations. However, it has been operating for many years, between 1997 until a couple of years ago. As members of the GATT and then members of the WTO, North African countries, which I mentioned, which particularly Egypt, Tunisia, and Morocco, have been bound by the TRIPS agreement, and as such were under an obligation to adopt new patent laws or revise the existing ones in line with their international obligations and protection standards under the agreement. The result of that was a new IP law in Morocco in the year 2000. Tunisia, there were two laws, one in 2000 for patents, one 2001 on trademarks, and Egypt, a revised IP law in 2002. Adjustment strategies, policy implications, and impact of national IP systems, as well as the legal framework and the innovation promotion, have been adopted in these countries in light of their new arising commitments. Sorry. If we try to, you'd look at this table about challenges and opportunities related to IP in North African countries, how the countries of the region could benefit from the IP regime, and what challenges are posed to them because of this regime. If you go to the side of opportunities, there have been definitely an improved IP infrastructure. And when we talk about infrastructure here, we're talking about the culture itself, the awareness, about the knowledge about the enforcement, about technical cooperation, capacity building, whether human capacity building or institution capacity building. Human resources, I already mentioned, national development strategies. And these national development strategies are aligned with the SDGs, with the UN General Assembly approved SDGs, particularly the focus on science, technology, and innovation. What do we mean by national development strategies? The development strategies are sort of three types. Countries that are a bit beginner at the level of IP or the IP system, they use what is called national IP development plans. This, for example, was implemented in a country like Sudan, is being implemented in Djibouti, is being negotiated in Mauritania, because these countries are already at a low level in the development of their IP systems. More advanced countries, relatively more advanced countries, they have the national IP development strategy, which is a strategy that is very comprehensive. It covers all stakeholders, not only the national IP offices. So this includes universities, includes research centers, include SMEs, include chambers of commerce, include sometimes even schools or high schools. So it covers the public and private stakeholders. The third is what's called sectoral IP policy. Sectoral IP policy deals with certain institutions. We have big institutions, big enough in countries in North Africa that these countries have requested WIPO to help them elaborate an IP policy for this institution. We have the case, for example, Biblioteca Alexandrina in Egypt. We have just very recently starting with Pasteur Institute in Tunisia. There are also other similar projects in the rest of the Arab region, but I'm just giving two examples from North Africa. The other opportunity is that there is a desire in most of the Arab countries, particularly, for example, in the Gulf countries, the 6 Gulf countries, which are not part of North Africa, but also in countries like Algeria. At one point, it was in a country like Libya, to move away from what's called the rentier economy or rentierism towards more entrepreneurial and productive economic activity. And they looked for IP as a motivation of innovation, as already mentioned by Professor Miguel in his introduction. The positive relationship here is very important between IP protection and innovation, encouraging innovation, promoting innovation. So these countries will help by this new drive concerning IP in their attempt to go away of the rentierism or the rentier economy, which either depends on volatile sources of income or of declining sources of income in some cases. Then there is the engagement of the new stakeholders, which I referred to earlier, which covers SMEs, NGOs, universities, research institutions, local communities, and others. If we move to the challenge side, then we're talking about one of the basic problem is still the lack or insufficient awareness of the importance of IP. And here we're talking about the question of IP culture, that the IP culture is not yet advanced and not yet widespread in the Arab countries in general, including the North African countries. The awareness of its importance, it's still perceived maybe less than before, but still among sectors in the society and sometimes among sectors of the policy-making institutions, perceived as something that doesn't necessarily go hand in hand with development programs and development plans, and even that could impede these development plans. So this still exists. Unfortunately, it's still, as I said, it's better than before. The situation today is better than 5 years ago or 10 years ago, but still it exists. Then the other challenge is political instability. You have a country like Libya, for example, where, of course, for the past 10 years and so, it's virtually impossible to talk even about intellectual property, although they talk. I mean, we have some Libyan officials or even ministers that come and talk to us in WIPO about, yes, the need for something related to IP, but actually this don't go beyond the verbal level because simply not in their hands because of the difficult political domestic situation in the country. But we have another kind of instability which is very serious, hampering the work also, is institution instability. Institution instability has two meanings. One of them is the senior management of the IP offices. In some countries there is a very quick change of the senior management of IP offices. And here, of course, this damages a lot. This undermines the effort of the country itself and the cooperation by WIPO with the country in order to enhance its IP capabilities and using this as a means to promote innovation and economic development. Because when you start dealing with a counterpart and then in a year's time this counterpart is changed or removed or replaced, then you have to start from the scratch again with a new interlocutor, and this doesn't help. But another type of institution instability is the institution itself. In some cases, the institution as such, whatever institution is dealing with IP issues, it's changed to another, or the mandate goes to another ministry or to another organization, and then this is even more challenging for cooperation from the external actors, including WIPO, as it is the organization with clear and explicit mandate in this area. The third challenge, of course, for North African countries is that related to funding and to resources. Here I'm talking basically about financial and technical resources. So funding has been, of course, a very serious challenge because many countries, not only Arab countries or North African countries, but many developing countries wouldn't set priority in their expenditures, the public expenditure of the government, to the idea of training people, for example, in IP, or even setting up institutions or setting up training institutions in the area of IP. So this would you have to look for, sources of fund. There's a couple of cases, for example, of North African countries that a couple of years ago came to WIPO and requested financial help to digitize their backlog of documents. And this is huge cost. And this is eventually had to WIPO and the countries concerned have to look to for third partners, developed countries or developed countries institutions that could contribute to covering this financial gap, because it was a very serious one. The amount, we're talking about millions of dollars actually in such an exercise. The other point, which is related also to problem of funding and financial resources, is the limitation on the expenditures on R&D activities. This is a very, very serious challenge. This is in most of developing countries. Again, the budget of the country, you would find maybe they are spending more on health, on education, but when it comes to R&D activities, in some countries, literally, the expenditure is zero. And let's say, why literally zero? Because there is an item in the budget for this expenditure, but in real terms, this item in the budget goes as salaries to the researchers. Because at the end of the day, these researchers are responsible to their families, to their whoever they are sustaining, so they have to receive the salaries. But what is left isn't enough at all to really finance or fund, serious research projects. So again, there is the reference to external or third parties, particularly from the developed countries, partners in this R&D activities, or to some international organizations, although these international organizations could provide the technical know-how, the technical expertise, but usually don't have the possibility of providing financial resources or funding that. Then another challenge is the legislative and regulatory framework. And here we're talking about, I mentioned earlier that some countries, I mentioned particularly Egypt, Morocco, Tunisia, revised their laws, national laws, in light of their international obligations. So this was a positive step, but still there is a need for more revision of the laws and regulations of countries of North Africa, among other Arab countries, in order to be in line with the development, with the technological development. Today we have, the pace of technological advancement is so quick, and this pace affects very much the nature of the protection itself of the IP rights. And if the national laws fail to adapt or to adjust to this increasing and accelerating pace of technological development, and its impact on IP, then there will be a problem. There will be a real serious challenge in how the laws related to the reality. We have, as Professor Miguel mentioned, he was talking about the fourth industrial revolution. So this fourth industrial revolution brought up matters that were not there before, and above all, legal framework and legal systems of countries at the national level have to deal with them in order to give the opportunity to deal with them at the international or multilateral level. Another challenge, of course, is the lack of coordination among the relevant national stakeholders. And here we are talking about at the national level, you have different stakeholders, as I mentioned before, other than the national IP officers. To what extent there is coordination among these stakeholders is a question mark, because in many cases, not only in North African countries or Arab countries, but in many developing countries, the level of coordination is sometimes very low, and sometimes in cases you find it non-existent altogether. And here sometimes the countries refer to WIPO to help this coordination, to help actually improve this coordination, or help proposing a strategy or a mechanism in order to create coordination among stakeholders. Another challenge is the IPR enforcement, the intellectual property rights protection enforcement. This is the question that we're talking about from the beginning. The question of enforcement is very central, because once you have effective enforcement, you are encouraging, inventors, you are encouraging innovators and creators to do the maximum they do, which would at the end of the day be a plus for the development plans and programs of the country. If enforcement is not there, then you should forget not only about local inventors, but also about foreign inventors, because they will not come to the country simply because there is no enforcement. They wouldn't guarantee their rights. So this would negatively affect flow of investment, transfer of technology, development even of local technology or appropriate technology. The last challenge I'll mention is the famous brain drain. In many countries in the region, in the Arab region, and particularly in the North African countries, there is a serious problem that you have the inventors there, they go, and this is related to the previous point of enforcement, they go to Europe or go to the United States or Canada in order to register their inventions there as patents. And they don't register them in their own countries. This literally means that actually in their own countries, when we count patents for countries at the end of the year, they don't have maybe let's say country X would have 49 patents registered, but in reality we find that they have 70 patents by their nationals, but registered in the countries of the North, in European or in America or in Canada or Japan or so. So this is another challenge that we face. Talking about moving to talk about the role of WIPO in fostering the use of international intellectual property as engine for growth and development. Here, of course, there are, several perceptions of how you see this question, from also covering the different components of intellectual property, whether copyright, whether industrial property by its components, patents, trademarks, others, whether you're talking about protection, whether you're talking about enforcement, whether you're talking about licensing. All these are dimensions of this challenge. In fact, we can easily say that the WIPO cooperates with the member states, with intergovernmental organizations, and with relevant non-governmental organizations. In addition to the stakeholders I mentioned before, private sector, SMEs, universities, research institutions, to realize the benefits of the IP system for the society of each country. The cooperation activities at WIPO take many forms. This include assisting in governments and individuals to use IP for economic development, building public-private partnership to address global challenges, and cooperating with member states to develop global IP infrastructure and build respect for IP. We'll take each of these three areas, to go in detail in them. So for the first function is assisting governments and individuals to use IP for economic development. Here we are talking about several levels of cooperation. The first is the general term of technical assistance or technical cooperation. And WIPO doesn't provide only or doesn't confine technical cooperation to governments or government agencies, but it does extend this technical cooperation to other users of the IP system. All of our activities in this area in WIPO are needs-driven and tailor-made. What does it mean to say needs-driven? It means that the country concerned has to come to WIPO and demand that. I mean, all countries are sovereign governments, sovereign states, so they have to come and say, we want WIPO to help or to cooperate in this or that area. So we cannot go and impose on a country or prescribe to a country something. And consequently, we tailor-made the assistance we provide for the needs and specificities of this country. Here there are national IP strategies, which I referred to, and there's what's called policy and legislative advice. What does it mean, policy and legislative advice? It means that you have a country that brings its law, which IP law, for example, goes back to 1950, and comes to WIPO and said, okay, we want to revise and update this law, so please give us your legislative advice on this law. What is needed to be done? This exercise, you might think it's an easy one, but actually it could take years from our side, from our teams, because it goes to the different substantive departments in the organization at the secretariat level, those dealing with patents, those dealing with trademarks, geographic indication, industrial design, copyright, and those dealing with enforcement, in order each to provide its input, and then we have a teamwork in order to provide a comprehensive feedback to the country concerned, very detailed and very pertinent one. The other area, other than the national IP strategies and the policy and legislative advice, is IP Office Business Solutions. What does this mean? This has become now one of the main sectors of the organization. It means, in briefly, IT. How to use IT to facilitate the work on IP, meaning particularly to build the capacity for the national IP offices in order to help them in the process of registration, process of examination of applications for patents and trademarks in a sort of automated manner that would save a lot of cost, but save a lot of time as well. So we have, for example, our latest program there is called IPAS. IPAS is Intellectual Property Administration System, and this system now is available in all the 7 languages of WIPO. In WIPO, we have the 6 UN languages plus Portuguese, so we have 7 languages. So this program now is used, for example, by 17 Arab countries, including almost all the North African countries except Libya and Mauritania. The other area of cooperation from WIPO with the member states and with the individuals is the human capacity building. And here there are a lot of areas. There are patents, trademarks, industrial design, geographic indication, copyright. And here we have an institution within the organization. It's called WIPO Academy. WIPO Academy is a huge training institution that developed a lot, particularly over the past 5 years. It was restructured in 2014 and started as early as 2015 to provide a lot of services. One of them is distance learning, but it's not the only one. The other one is professional development programs. The third one is partnership with universities all over the world to provide masters in IP. The fourth one is to help countries in different parts in the developing world, including in Arab countries, to develop their own, let's say, original or native programs of IP at the different level of educations, even at the school level, not only at the university level. So almost all the countries of North Africa benefit from this service right now, except Libya for clear reasons that I mentioned before, but Egypt, Tunisia, Algeria, Morocco, Mauritania, they benefit from this service of the WIPO Academy. If we talk about the technical assistance for user of IP, the most important that we have now is TISC, what we call TISC program. TISC program is Technology and Innovation Support Centers. And in order for the country to go in partnership with the WIPO for TISC, it has to negotiate and sign what we call an SLA, Service Level Agreement. And now we have almost 13 Arab countries that have these agreements with the WIPO. This includes Egypt, Algeria, Morocco, and Mauritania. Not yet in Tunisia, but Tunisia is coming soon in line of this service. What does it mean, this TISC? What does it mean? It means that the National IP Office is a national coordinator, but the TISC centers are in different places, are in different ministries or research institutions or universities, or even in some countries in chambers of commerce, providing access to the local staff of these different centers about high quality information technology, particularly technology that are existing or are related to patents. The second program that we have, which is called the Pro Bono program, it's the Inventor Assistance Program. This program tries to link the inventors with attorneys, with IP attorneys that are willing to provide their services to these inventors for free. And this project started as a pilot project. When we say pilot project in WIPO, we mean one country from each region. And we have 4 regions, Latin America, Caribbean, Asia and Pacific, Africa, and the Arab region. And the pilot project country from the Arab region was Morocco. And the project went very successfully there. And it managed to match, the need by the inventors, who are resource limited, with the patent attorneys. The third assistance provided for users of IP is patent drafting assistance. Patent drafting is a very complicated exercise, and it needs a lot of training, for those who undertake it. In many cases, patent draft is undertaken by officials from the national IP offices, but in some cases it goes beyond that. It goes to what we call agents or agencies, particularly in Arab countries that exist in a number of countries. So the service that WIPO provides here is not confined to the national IP offices, but other firms or institutions that provide this training for the patent drafting. Finally, it's the universities and research institutions, the public research institutions. Here we introduced a WIPO program 4 years ago called IP Policy for Universities and Research Institutions, meaning that WIPO has been providing help and support to the countries, developing countries, including or actually particularly Arab countries that benefited a lot from that, in the area of how to help each university to elaborate its own IP policy. And the IP policy of the university wouldn't only be a registry of the inventions or the innovations done by the faculty, but also, and equally important, by the students. You could imagine that there are some universities in the United States that on an annual basis, they register from their students more than 1,000 patents. So that's quite a number. This attempt has been extended to Arab countries. Now it covers Egypt and Algeria and Morocco. Also, hopefully it will be soon introduced into Tunisia as well. The second kind of service that WIPO provides is the public-private partnerships. And here we have a number of examples that I'll share with you. One of them maybe I referred earlier to in my earlier presentation this morning. But the 3 others are totally new. The first is the ASPI. The ASPI is access to specialized patent information. And here we're talking about special data tools and services that are lacking in developing countries, including Arab countries and North African countries, that are made available to these countries and to their relevant institutions through WIPO. Second is the PAT Informed. This is a service related to global health community, particularly those involved in the procurement of medicines, by facilitating easy access to medicine patent information. The third is also related to health or to public health, which is WIPO Research, which is one of the initiatives of WIPO 5 years ago. It analyzes the development of medical products to treat neglected tropical disease, malaria, and tuberculosis. As I mentioned in my previous presentation, this covers also not only WIPO, but the tripartite cooperation and partnership between WIPO, World Health Organization, and the World Trade Organization. The fourth service I would like to refer here in the context of public-private partnership is the ABC. The ABC is the Accessible Book Consortium. This is an initiative that was created in the aftermath of the conclusion of the Marrakesh Treaty, which I referred to earlier, related to exceptions of intellectual property in favor of the blind and visually impaired. The ABC works to increase the number of books worldwide that in accessible formats to the visually impaired and the blind and make them available to the people who need them. ABC now has cooperation with 2 countries in North Africa. It has concluded an agreement with the Biblioteca Alexandrina in Egypt and and with the National Public Library in Tunisia. So there is now work on a limited number, but a good beginning of tens of books to change them into a way that's friendly, or a printing way that's friendly to those who are visually impaired. The third type of cooperation is the global cooperation, and here talking about the global IP infrastructure. So actually WIPO manages tens of global database and information technology platforms for cooperation among and between offices. Here I'm talking about national IP offices in areas such as exchange of search and examination results. We have a very ambitious program in WIPO about the search and examination of patents. This means training officials from the different national IP offices on how to find information on patents that they are examining related to results carried out by other offices. To make it clearer to you, let's say, for example, an invention came to the National IP Office in Tunisia, and they found out through certain training that WIPO provides, they could find out what happened with this same invention or same application for patent when it was presented for the US Patent Office or with the European Patent Office. Sorry. So this service and this actually examination and of search results, this is provided by WIPO, basically to national IP offices. The second activity in this regard is the cooperation between WIPO and international and non-governmental organizations as well as member states in order to help better understanding of IP and more respect to IP. And here we go back to the question of promoting an IP culture in the region. Another example I would like to give here is the question of the GII. The GII is the Global Innovation Index. This has been published by WIPO over the past 12 years. The latest was published in last July 2019. And this, we have a ranking of the 129 countries of the world in terms of their policy of innovation policies and strategies. So we have the ranking from 1 to 129, and you have there all the countries of North Africa except Mauritania are included, except Mauritania and Libya, sorry, they are included there. Libya because of its domestic situation, Mauritania because of the low level of indicators, so it's not included in this innovation index. But this innovation index started at the beginning as a low-profile report, annual report. Now it gained a lot of coverage, a lot of reputation and image worldwide, because it clearly became one of the documents that, for example, the World Bank, the regional development banks refer to when they are considering options for supporting a country or for supporting investment in a country. I just want to share with you examples of, I mentioned many of the activities the WIPO is holding in North African countries, but I want to mention now specific success stories that we have in this regard. We had a project which was again started as a pilot project in WIPO 5 years ago. It's called Intellectual Property and Tourism. And this started with 4 countries, as I mentioned in the other case about the pro bono. So this was also 4 countries, 1 from each region, and Egypt was the country from the Arab region, representing Arab region, and it's a North African country, of course. So this was successfully concluded last April. And this helped Egypt on 3 things, on 3 results. One is what's called the Ancient Civilization Museum, which is situated in Cairo. And this was a new museum, but it was helped to elaborate an IP policy for the museum. The second is the Holy Family, the Holy Family Voyage, or the Holy Family Tour in Egypt. This is again another touristic project that Egypt has been working on. And the third was Bibliotheca Alexandrina, which developed later to this project, particularly consecrated to elaborating an IP policy for Bibliotheca Alexandrina. The other project, the other successful project, is TMO's project. TMOs is Technology Management Organizations or offices, depending on each country. This was successfully concluded in Tunisia 3 years ago, and is still undergoing with much success in both Egypt and Algeria. This project is related to the IP offices, of course, but it doesn't benefit the IP office. It benefits other stakeholders like technoparks or the like, that actually establishing their technology management offices in order to involve the question of technology and technology transfer in their work. Then there is the TISC project. The TISC project is extremely successful in Algeria, Morocco, Tunisia, and Egypt. Now Algeria is one of the top countries actually worldwide. They have 74 TISCs, 74 centers for technology and innovation support, followed by Morocco, which have more than 50, followed by Egypt, which has more than 40. Then Tunisia come after that. The ABC agreement, I mentioned already, their agreement with the organization in Tunisia, IPSAR organization in Tunisia, for the visually impaired and the blind. Then there was a series of green technologies, promotion of green technologies that started with Algeria very successfully last year, and they are expanding this year, covering Algeria, Morocco, and Egypt. Here again, we have a program in WIPO called WIPO Green. WIPO Green deals with the relationship between IP and climate change. And it's this program that's trying to promote access to green technologies in the developing countries, including North African countries. Then there is one area which has been relatively new to North African countries and Arab countries. We have a center in WIPO called the WIPO Center for Arbitration and Mediation. And this center has been more or less confined its activities in the past to other regions, not to the Arab region. But last year it started with Morocco, a very successful cooperation program with Morocco. And then it's extending this year, 2020, to both Algeria and Egypt to reach MOUs with them, in addition to Tunisia as well. Other than that, we have region and sub-region national activities that are done annually for the benefit of multiple stakeholders to foster the use of IP development. In conclusion, I would share with you that the situation of IP system in the North African countries is not an ideal, it's not an optimal situation. Also, the use by the North African countries of possibilities, potential, and opportunities offered by the international IP regime didn't reach its optimal level. However, what we can attest is that there has been progress. Leaving the case of Libya aside for clear political domestic reasons, but the other 6 countries in North Africa have been advancing in terms of their IP system with varying degrees of success, because also their starting point was different from one country to the other. Mauritania is still at early levels of the development of the IP system and culture, while the other countries, Egypt, Tunisia, Algeria, Morocco, are more advanced. Also, there is variation in the component of IP. We have among these countries, Egypt is the most advanced in patents. On the other hand, Morocco is the most advanced in trademarks and industrial designs, and Algeria is the most advanced in copyright. They are almost one of the few Arab countries and the most advanced Arab countries in Algeria, for example, developing what we call collective management organizations, which exists, of course, in each and every country in Europe, in the developed world, in Asian, even, and Latin American countries. So we are not yet there, but there has been progress and there has been advancement towards the fulfillment of the objective of these countries in IP, and more particularly towards linking their IP policies to their innovation policies, to their development plans in general, social, economic, cultural, and technological plans. I'm sorry for taking much of your time, and I hope I would be more than happy to have any of your questions or comments or to receive. Thank you very much.
Thank you very much, former Ambassador Walid Abdelnasser, for your presentation. Now we open